In a famous opinion, in an in-depth jurisprudential discourse on choice of law that examined the laws under which the accused would have been tried in his host nation had the crime been charged and not ignored by that government, and defined for posterity an unlawful order thusly: the distinguishing mark of a manifestly unlawful order should fly like a black flag above the given order as a warning reading prohibited, not mere formal illegality, hidden or half-hidden, not the kind of illegality discernible only to the eyes of legal experts, but a flagrant and manifest breach of law, certain and necessary illegality appearing on the face of the order itself. The clearly criminal character of the order or of the acts ordered, and illegality clearly visible and repulsive to the heart, provided the eye is not blind and the heart is not stony and corrupt. That is the extent of manifest illegality required to release a soldier from the duty of obedience upon him and make him criminally responsible for his acts. Attorney General of Israel v. Eichmann. Similarly, in an American trial reviewing heinous conduct, one jurist noted in dissent, while this test is phrased in language that now seems somewhat archaic and ungrammatical, the test requires that the essential ingredient of discipline in any armed force is obedience to orders, and that this obedience is so important it should not be penalized unless the order would be recognized as illegal, not by what some hypothetical reasonable soldier would have known, but also by those persons at the lowest end of the scale of intelligence and experience in the services. This is the real purpose in permitting superior orders to be a defense, and it ought not to be restricted by the concept of a fictional reasonable man, so that, regardless of his personal characteristics, an accused judge after the fact may find himself punished for either obedience or disobedience, depending on whether the evidence will support the finding of simple negligence on his part. U.S. v. Cali. In Eichmann, in defense, the accused argued in conclusion, faith in leadership is the basic principle of all states. Deeds are silent. Obedience is blind. The state can rely on these virtues alone. It depends upon the success of politics, whether these virtues are rewarded. Where politics have failed, the order is considered as a crime in the eyes of the victor. He who has obeyed is unlucky. He has to pay for his loyalty, the gallows or a decoration. That is the question. The deed which fails will be a common crime. If it succeeds, it will be sanctified. Attorney General of Israel v. Eichmann. But that tribunal historically replied, if by these words counsel for the defense intended to describe a totalitarian regime based on a denial of all law, as was Hitler's regime in Germany, then his words are indeed apt. Such a rule seeks to turn the citizen into an obedient subject who will carry out an order coming from above, be it in order to commit an injustice, to oppress, or to murder. It is also true that under such a regime, the criminal who obeyed a criminal leader is not punished, but on the contrary, is rewarded. And only when the entire regime collapses will he become amenable to justice. But such arguments are not to be voiced in any state in the world which bases itself on the rule of law. The attempt to turn an order for the extermination of millions of innocent people into a political act with the aim of thus exempting from their personal criminal responsibility those who gave and those who carried out the order is of no avail. And do not let counsel for the defense console us with the promise of a world government to come, when such acts of state will become a thing of the past. We do not wait for such a radical change in the relations between nations in order to bring a criminal to judgment, according to his own personal responsibility for his acts, which is the basis of criminal judgment all over the world. As the Attorney General said, would that the Jews, under the rule of Hitler, had been granted the status and privileges of prisoners of war. But this war took the form of deporting helpless people to be slaughtered by citizens of the state in which they lived, without any reason save that of gratuitous hatred and without any aim save that of extermination. It is true only that the state of war between Germany and the Allies created conditions convenient for the implementation of the final solution, by enveloping the territory under German rule in a smokescreen which veiled much of what was going on there from the eyes of the world, and made it easier to perpetrate the slaughter without outside interference. The accused's evidence in this case was not truthful evidence. In spite of his repeated declarations that he was reconciled to his fate, knowing the gravity of the activities to which he had confessed of his own will, and now his only desire was to reveal the truth, to correct the wrong impression which had been created in the course of time in regard to his activities in the eyes of his people and the whole world. In various sections of this judgment, we have pointed out where the accused was found to be lying in his evidence. We now add that his entire testimony was nothing but one consistent attempt to deny the truth and to conceal his real share of responsibility, or at least to reduce it to a minimum. His attempt was not unskillful, due to those qualities which he had shown at the time of his actions: an alert mind, the ability to adapt himself to any difficult situation, cunning with a glib tongue. But he did not have the courage to confess to the truth, not about how things actually happened, nor about his inner convictions to the acts he committed. We saw him again and again winding his way under the impact of the cross-examination, retreating from complete to partial denial. And when he left no alternative to admission, but of course, always taking refuge in the plea that in all matters, great or small, he was acting on explicit orders. The question which arises, why did the accused confess before Superintendent Less to a number of incriminating details of which, on the face of it, there could be no proof but for his confession, in particular to his journeys to the East, where he saw the atrocities with his own eyes? We cannot search the depth of the accused's soul now, while he is under arrest, to discover what caused him to do so. Various theories may be put forward to explain these partial confessions, but this would be futile for the purpose of a legal evaluation of his evidence. Suffice it to say that in our view, these confessions did not add up to credibility to his evidence before us, as regards all those matters in which he was found to be lying. This advertisement was authorized by Mike Webb.